Welcome to Forum 360, the show with global perspective, but a local view. I'm Sally Henning. We are honored to chat with a distinguished guest today, Dr. Juscelino F. Colares, who has the challenge of teaching the same perspective, both local and global, at Case Western Reserve University Law School. Professor Colares is the Schat van den Einden Professor of Business Law, that's easy for me to say, School of Law co-director, the Frederick Cox International Law Center School of Law. He's professor of the Department of Political Science of the College of Arts and Sciences, and the director of the JD MA Political Science program. And in his spare time, he comes on to Forum 360. Thank you so much for coming.
Thank you for having me, Sally.
So we're going to be talking today about teaching law students, particularly about the law, both from a global perspective and the local view. But I just can't help but opportunistically ask you about the Supreme Court's decision this morning in Trump versus USA on the subject of presidential immunity. So hopefully you won't mind me asking you to comment on this decision this morning.
Well, I have not read the opinion in full, but what
that
I got from it...
That never stopped me from commenting.
Yes, but exactly. The president is basically, the court ruled that the president is absolutely immune from criminal prosecution for any official act he commits during his presidency or her presidency.
Okay, really?
And yes, but that absolute immunity does not extend to unofficial acts. So I think what's left is the question of what constitutes an official act, which obviously the lower courts will have to litigate first before, if ever, any case comes to the court.
So does that mean that the case is over or not?
I would say that if you add with the ruling on the Friday case, the Fisher ruling that basically got the obstruction charges out from the January 6 cases, at least in the DC arena, where Jack Smith is attempting to prosecute President Trump, half of his charges are out now. So the question is whether the judge determines, or he determines by himself. I don't think that that's his inclination, judging by how he has operated in past prosecutions, that he should basically stop and then have a superseding indictment on 2 counts, or whether the case is viable. Maybe based on his aggressiveness, I would say, in terms of litigating the case, I would say he's probably going to continue with the 2 remaining charges. With respect to the, with the Florida case, the classified documents case, there's a very interesting challenge to his his appointment as counsel, as independent, as special counsel. As you know, the independent counsel statute has lapsed a long time ago, and basically the Justice Department is proceeding by regulations, internal regulations. But the way Jack Smith's appointment was made, this might be getting to a bit of weeds. He is the Attorney General for all matters involving the classified documents and the January 6 cases against President Trump. And as the Attorney General with respect to those 2 cases, he has enormous power, and there is a challenge before Judge Cannon in Florida whether Jack Smith has needed to have to go through Congress, through the Senate confirmation process, because he's a superior officer of the United States, and that's a very strong argument, and I think that is enough to cause a federal judge or a good judge to pause, and I think that's where we are right now, and among other issues that have popped up last week. So the Florida case is not likely to come to a trial, I would say, before the elections, the November 5th, right? This year's 5th, November 5th, the first Tuesday of November, yeah. And the DC case, January 6th case against President Trump, where I think where he's accused of of engaging in coordinating with the January 6th Capitol riot. I don't think, I mean, that judge now, I think her name escapes me right now.
But you must get a lot of calls to comment on these various cases, and I notice you do a great number of interviews.
I do, but I do mostly in the areas that I practice, which is more like that I practiced or that I teach, trade law and procedure in the federal courts.
Well, let's talk about your fascinating background that led you to this place at Case Western Reserve University, where you get called by journalists and trade organizations for comments on Supreme Court cases regularly. How long have you been at Case Western?
I've been at Case Western now for 13 years. They have an excellent media department, so props to them. So they have an excellent media department, and I think it's an important function of, I think, law schools and of professors that have tenure to speak to society and help clarify the issues of the day. Not only the more complex issues that I think the general public never sees, but as you see in these, June is always a ripe month for law professors in general, because there are all these Supreme Courts, the most significant ones, that tend to be dropped in June.
Yeah, a lot to read. A little bit about you for our audience. I have to ask these extremely personal questions. So you're from Brazil? I
was born in Brazil, born and raised until age 15. And then I came to the U.S. as an exchange student to Louisville, Kentucky. And that's where I went to for my senior year in high school. And that changed my entire life.
And how so? How did that change your entire life?
Well, it confirmed my from early childhood, I had an idea that I wanted to move and live in this country.
How many languages do you speak?
4 or 5.
So it must have been incredibly difficult to come from a country where they speak Portuguese to come into school in the United States. How were you able to make that transition?
Well, first, it's people were very welcoming. And second, my American host dad, right, was David Hirschberg. He was the chair of the Romance Languages Department at the University of Louisville.
Oh my.
And he actually spoke Portuguese, but he never spoke Portuguese or Spanish or Italian with me.
Really?
Because, the moment I arrived, he told me, do not speak any Portuguese, do not write Portuguese, avoid calling your parents if you can until Christmas. And I arrived in late June. And he said, if you do this, you're going to be so immersed.
Immersion techniques.
Yes, completely immersed, so that your accent's going to be as good as possible. I was over, the general age is like 15, that you basically, 11. If you learn before 11, you have you basically will not have an accent. But if you don't want to have an accent, work as much as possible in your immersion. That's what I did. And so I spoke with my family once in July, and then I only spoke again with my family in December.
Pretty tough.
Yeah, it was nice.
Pretty tough. How old were you when you went to law school?
After I graduated, I was 16 years old. It was an undergraduate degree. So in Brazil, it's an undergraduate degree.
Wow.
Yeah.
Now, your background is amazing. At one point in time, you clerked for the French Supreme Court.
Yes, the French Constitutional Court. I clerked for the Chief Justice.
The Chief Justice.
Yeah.
How did that come about?
Well, I was a law student at Cornell University, Cornell Law School.
In Ithaca, New York.
In Ithaca, New York. And there was a French professor in the faculty, and she had a connection with a judge that had just been appointed to the French Constitutional Court, a judge from the French Supreme Civil and Criminal Court, la Cour de Cassation. And this judge introduced me to the Chief Justice of the Constitutional Court. And he wanted an American clerk. And so they got, at the time, a fake American, because I was not yet an American citizen at that time in 2008. And so I went there because he wanted me to do research on US law and other countries' law, because France at that time...
The comparison of laws.
Yes, because the French National Assembly and the Senate had approved an amendment that allowed, for the first time since the French Revolution, the French Constitutional Court to review as applied challenges to French statutes and executive decisions. So that was a new thing. Since the French Revolution, the French courts never dealt with as applied challenges. The moment to challenge the constitutionality of a French law was as the law, within a 30-day window before the president signed the law. And then you could invoke the authority of the Constitutional Court.
Before
In
you know what the law's
2008, they got
about.
that authority. So they wanted to know how other courts do it. And I was picked because I spoke French, and I had been trained in America. And they have a very significant interest in the Supreme Court and how American judges decide.
What a challenge.
It was, because I had to go back to my written French and kind of beef it up in terms of legal French, which is quite different from the regular, French letter writing French.
Wow.
Yeah.
It's amazing. So then you were there for 2 years?
No, I was supposed to have been there for 2 years, but I ended up staying 1 year. My eldest daughter wanted to move back to the States because she wanted to move to high school in America. And she made a big deal out of it. And so basically, after 2 months in the court, I had to decide if I was staying for another year, because otherwise they would have to begin the process of recruiting my replacement.
So then you came to the United States?
And then I chose, but then 3 months later, she was loving Paris. And then she said, I want to stay 1 more year. And it was too late, because I was already helping recruit my replacement.
Too funny. So then you came to the United States again?
Then I came back, and that's when I got an offer from Case Western.
Wow.
And then I had tenure from the law school I was before, Syracuse University, College of Law. And then Case gave me an offer, and I came.
So what has been the most difficult thing about being a professor at Case Western?
I wouldn't say at Case Western, being a professor in general, a law professor in these times. Except by the time students come to law school, they come with a significant, they are young adults, they come with strong opinions, as they should, but they come with this notion that law is about arguing for position. And to a certain extent, law is that, but that's not at all what law is all about. Law is about reasoning from statutes and the Constitution and from precedent, and you have to reason from principles. And not necessarily, you don't start reasoning based on a particular policy preference that you have, or a particular predilescence, or particular sympathy towards a party or another, especially not in law school, because you're not representing anybody. So that is a shock to them, because that we try to teach, at least I try to teach students from that they have to reason from the statutes.
We're going to be talking about teaching students. And first of all, I want to ask how you teach them to distinguish between both global issues and the local ones, and who their audience is. But first, I want to remind our audience that you're tuned into Forum 360. Our special guest today is Professor Dr. Juscelino Colares.
That's right.
And it's such a delight to have you here on our show. And I'm Sally Henning. So we were just talking about teaching students, and how do you teach them the perspective, both global and local? How do you do that?
Of course, we don't. First of all, recognizing that we don't live in the world in isolation in the world, right? Recognizing that there are major events happening right now in the last 70 years. I would say, up to like 5-6 years ago, the last 70 years had been pretty much kind of an incremental. Greater, I would say, globalization or integration of world economies. And then we've seen the rise of China and the rise of the BRICS, Brazil, Russia, India, China, and other countries, and the so-called G20. So we don't live in a world where America is so powerful anymore. America is still very powerful, but that we need to, pay attention and cultivate our relations. But at the same time, we need to do that with an eye to our constitutional structure, and I think that's the point. That's the thing that I think this is where the big value add of law schools should be. The idea that yes, we can come up with these ideas of how we want to regulate certain issues that involve transboundary problems. But we have to understand that we also have a constitutional structure that binds the different branches, right? The executive, the Congress and the courts, and even the federal government.
There are
right?
rules.
There are rules.
There are rules.
And that you cannot just, basically immediately think that because something is percolating as an international consensus, or at least a consensus with our European allies and Japan, etc., that necessarily has to become the law of the United States. There are a number of things that really, in the Constitution, principles that guide that transposition of those values or those agreements or those, aspirational goals, I would say, in some circumstances, into becoming law in the United States. And I think that the world out there is not preparing people to understand that there are differences. We have a pretty specific and special country, where we since the founding, we have separation of powers. We have, it takes basically two branches to pass laws, right? Bicameralism and presentment. Right? The two chambers have to approve and then present to the president. The president has to sign or veto, and
the next step,
the possibility of an override. And the next step is application of that law by the executive branch or agencies or by the states, etc. But then the judiciary needs to concur that in a specific case, right, in a specific case or controversy under Article 3, that law is constitutional, that statute is constitutional. So it takes really three branches to actually get laws to, in a way, restrain liberty or restrain our conduct. And that's part of, the idea of that this country, the core of this country is the idea of ordered liberty, right? That the principle is liberty, but it needs to be ordered. And for the purpose of having a system of freedoms, we need some sort of order. We need statutes. We need we need these decisions, but they need to be obedient, right?
And according
respect the constitutional boundaries.
And according to the court, recently, not so many regulations.
Correct.
I'm sorry.
Correct.
So you're talking about teaching students.
You're talking about Loper Bright Enterprises v. Raimondo.
The
case that reverses Chevron.
The Chevron decision, which said
that came out Friday.
They no longer give deference.
Right, courts are no longer required to defer to agency determinations.
Were you surprised by that decision?
I'm sorry, I was not.
Okay.
I was not, because you could see it. You could see it coming. You had the courts. Well, Chevron passed in 1984, right? It was announced in 1984.
Before you were born.
No, I was born before that. But Chevron does have a very. It provides a kind of a rubric for how judges look at agency decisions based on how agencies interpret statutes. But there are a couple of problems with that decision. Well, first, the most obvious one is there is a statute that Congress passed in 1946, just as the administrative state was getting larger, right? Which started with President Wilson. It did not necessarily start with President Roosevelt or FDR, but it started with President Wilson. This enlargement of the federal government,
administrative state.
Of the administrative state. And Congress wanted to rein in the powers, the administrative of administrative agencies, and it passed the Administrative Procedures Act. And Section 706 of the statute specifically says that the courts have the ultimate authority, or delegates to the courts, the ultimate authority to determine how statute should be interpreted. And Chevron, in a way, basically says, oh, yes, but you courts, you judges, you should defer because agencies have expertise.
Expertise, right.
And a number of judges since that time were not very convinced. And of course, Chief Justice Roberts, who became Chief Justice in 2005.
The minimalist.
He's a minimalist. He's very systemically minded, right? He's looking at the whole. It's not only the case before him, but the cases that are coming, the impact of the judiciary.
And you do that with your students, don't you? You try to get them to look at what they're going to be impacted.
I try, but my students tend to be skeptics.
Okay.
Because they already arrived in law school thinking, oh, it's sometimes it's some students come to law school thinking it's all a means to legal arguments are a means to an end, right? And that's not the case. I mean, there are certain principles. In the case of Loper Bright Enterprises, the case cited last Friday, the Supreme Court went out of its way to be very clear. Listen, this is not just, this is a specific statute, the Administrative Procedures Act, Section 706. It delegates to the courts the ultimate authority. What are the courts doing delegating something that's not theirs to delegate? The Congress delegated that power to them. Why are the courts saying, no, you judges, you should defer to the agencies because the agencies have expertise? No, that's that's part of the judicial function. I mean, I'm not even mentioning the Marbury v. Madison, the idea that the courts have the ultimate authority to interpret the constitutionality of any government act, including laws. But the statute itself said that already.
How do you get your students to think about the future when they need to be able to convince a client, or more importantly, a judge or a jury, the trier of fact, whoever, or law, how do you get them to be results-oriented, to think beyond the initial law that they're learning? I
think the basic notion that read the statute first, right? Read the statute, read the precedents first. Don't fall in love with a position, right? Just because it seems fair or you're more sympathetic to it or the particular party. The moment to fall in love or to be emotionally motivated with respect to a case is when you pick your clients and their causes. But once you pick your client, your cause, what you need to do, it's the policy kind of world, because you're going to be speaking to a judge. The judge is like a law student writing a final exam, right? It's not my phrase, but...
I never heard that before.
Yeah, it is. And the judge basically, you have to convince the judge, you have to make it easy for the judge to rule for your client. And the best way to make that is to make your arguments to reason from the laws, to reason from statutes, not from positions, not from preferred positions, or not adopting preferred positions or the position of your client, and then trying to, try to nitpick arguments and say, see, for these reasons, this is why this is right. No, you say what the Constitution or what the statute says, and if necessary, what the Constitution says. And then you try to reason with the judge why this particular outcome that your client wishes falls within what the statute provides for your client. And that is a unique ability, right? There's a famous quote from Harvard Law professor Lon Fuller. He said that law governs men, reason the law. Reason governs the law. So law is not just about what the content of the law is. Law is logic, is the reasoning behind how you use law to a particular end. And law is governed by reason and logic. You cannot just come to the court and make a conclusory argument. This is a right because this is what's humane. And I mean, I always like to remind my students, under the masthead of the Supreme Court, it says equal justice under law, right? Without the law as the dough, right? You can't get justice, right? The law is what you need to work with to get to justice. It's not just by arguing in equity, that you're going to get to your end. There are some cases where you can do that, but those are exceptional, where there is no remedy in law. Law is the place where you go to.
What's been the most surprising thing in your teaching at Case?
The most surprising thing at my teaching at Case, I think it's the notion that when I used to teach first-year courses, civil procedure, right? I stopped 3 years ago. I'm teaching more, the second and third-year courses. I always had the impression that my students always thought that there was an answer there was always the same answer to every question. It depends. And I always struggled with that. And I said, 95% of the cases, there is an answer. Otherwise, judges would be deciding it depends all the time, and you don't see judges doing that, right? So basically, there is an answer to questions, and that you have to find it, and you have to find it by reading the statutes, by reading the precedent, and doing the work. Right? What advice do you have? Yes, go ahead.
What advice do you have for young people who might be interested in law?
My first advice would be, if somebody tells you to go to law school because you are argumentative, because you like to argue, don't take that as necessarily good advice, because law is not just about arguing. Law is about reasoning, and reasoning requires you to know the specific structure of rules. There are certain rules that you have to follow, and it's just not free willing. It's just not picking and choosing what argument favors me and forgetting others. You have to address even the arguments that are counter to yours. But you have to start with your strongest argument. And your strongest argument, ideally, is grounded in some statute or in some Supreme Court decision or in some relevant appellate court precedent that basically you can derive, you can associate with your client's situation. Not that you can just throw arguments, just because you like to hear yourself speak. So my general advice is, if you go to law because you're escaping organic chemistry, or if you go to law because you're escaping calculus, or you're escaping areas that you find that are very full of rules and they're very, maybe you don't like numbers. Law is a lot about reasoning, and reasoning
is where you should try.
It's logic. All human thinking is about logic.
Thank you. On behalf of Forum 360, we thank our special guest, Professor Colares from Case Western Reserve Law School, for appearing today. I'm Sally Henning.
Forum 360 is brought to you by John S. and James L. Knight Foundation, the Akron Community Foundation, Hudson Community Television, the Rubber City Radio Group, Shaw Jewish Community Center of Akron, Blue Green, Electric Impulse Communications, and Forum 360 supporters.